So let's get started. Does the WTO have a future, according to you, James?
Definitely, I think we are recognizing the importance of WTO more than ever before.
The global trading system is in flux. Institutions like the WTO, once the cornerstone of a rules based trade law regime, are now in a state of paralysis. This is particularly true in relation to the dispute settlement mechanisms, which have now not functioned for a considerable period of time. There are major questions now being asked about the future of global trade. India finds itself right in the middle of this churn. As a large emerging economy, it has had to respond to unilateral tariffs imposed by several countries, navigate legal challenges at the WTO, and recalibrate its own domestic tariff regime in light of shifting global priorities. The question at this point of time is, can India leverage its expertise to lead in reforming global trade governance, or will it continue to remain a follower? And what of the future of the global trade regime? Where do we see it going from here? Joining me today on Justify is a very special guest. James Nedumpura is the head of the Center for Trade and Investment Law, established by the Government of India under the Ministry of Commerce. A seasoned international trade lawyer and policy advisor, James has worked at the intersection of law and policy and diplomacy, advising on WTO litigation, free trade agreement negotiations, and India's response to global trade disputes. He advises the government on international trade, investment, and dispute settlement matters. He's also taught at the Jindal Global Law School, where he was a founding faculty member, and has worked as trade officer legal with UNCTAD India program. James was appointed as the India chair of the WTO Chairs program in 2022. There couldn't be a better person to talk about this issue. James Nedumpura, thank you very much for joining us on Justify. So let's get started. Does the WTO have a future, according to you, James?
Definitely, I think we are recognizing the importance of WTO more than ever before. So WTO has been a central pillar in shaping international economic law and providing a predictable and stable trade for a fairly long time. So some of the issues actually came up, around 2010. You can say immediately in the aftermath of the 2008 financial crisis. The one particular reason was actually the rise of China, and China became an extremely competitive economy. In many sectors, the United States lost its advantage, or you can actually say the globalization forces led to some of the businesses or production facilities in the United States moving to other countries. So there has been a bit of backlash. And then there has been some kind of a disenchantment, not only in the United States, especially in the advanced countries or in the Western world, about this new international economic order, or you can say the neoliberal international economic order. So this has been appearing for a while, but when we really see the events in the last few weeks and months, we really understand the importance of WTO. So we had to really contextualize why WTO is very important. Really, if you go into the history of the multilateral trading system, after the Great Depression, after the Second World War, the international community, led by the United States and the European countries, really wanted to have the pillars in order. And one pillar was the International Monetary Fund, which was dealing with the macroeconomic matters, then the World Bank dealing with the reconstruction of the economy through development assistance, and the International Trade Organization, which never happened, which never came into being because of the internal politics within the United States. But the principles are twofold. One is actually most favored nation treatment, and the second is national treatment. And these are the pillars of the international trading system. So what had actually happened today is that we have got a patchwork of trade agreements, sometimes not even trade agreements, transactional agreements. They are not like any international treaty. The value of these agreements is very much doubted, how long they will be enforced. So we have got a category of executive trade agreements. And I don't think that they really become international treaties within the meaning of the Vienna Convention. So we have got a very, extremely, you can say, ad hoc arrangement at the moment, and no one can be certain about the value of these ad hoc arrangements into the future.
Absolutely. So I think if I were to just take it from there, that you're absolutely right that the WTO, of course, as in came up in a particular historical context, as in performs a very critical function in ensuring that there is free trade in the world, and has always had some pressures. But at this moment, when we find that some of these pressures are boiling over, particularly with the internal politics in the United States, there is always a question mark, and as you rightly pointed out, with the emergence of China and what that does to the future of this regime, and also an increase of bilateralism. And there are many articles that are being written recently, particularly in op-ed pages, on how multilateralism is dead, and this is the time for bilateralism. So, given these developments, a kind of increasingly isolationist United States, a growing China, which has an on off relationship with a global trade order, and India seeming to move towards bilateralism, how do you see the WTO pushing back or standing its ground in light of these developments?
Yeah. So again, I think this is a response to your first question as well. Does WTO have a future? The one problem with the WTO is perhaps the decision-making nature of the WTO. And we know that now there are 166 members within the WTO. It is quite difficult to get an agreement under the WTO done. So we have only very limited success stories. One is actually the trade facilitation agreement, and the second is the fish subsidies agreement part 1. So it is quite difficult to, for WTO to manage very complex trade agreements in the current times. And therefore, countries are opting the free trade agreement option. So ultimately, the objective seems to be the same thing. The destination seems to be the same thing. You need to have a liberal world order. Countries will actually reduce their tariffs and non-tariff barriers. And they will also take other categories of non-trade commitments, like say in the labor environment, sustainability concerns for that matter. So on the one hand, I think there is a certain amount of parallelism. The ultimate objective of the world WTO is also liberalized trade and removal of unnecessary barriers to trade. And the free trade agreements are also achieving the same thing. So to an extent, I would actually say that, I would tend to agree with that notion that the plurilateral agreements or the preferential agreements are also building blocks of a trading system. They cannot be completely contradictory to each other. So there has to be some kind of a convergence. But what is happening at the moment is that the WTO principles are completely ignored, and bilateral trade is happening in a very ad hoc manner.
That's right.
Right. That's the problem with the current system. So my feeling is that it will be temporary in nature. After all this comedy of errors, we will actually get a world order that is back to its original functions.
That's right. That's very Shakespearean of you. And it is an optimistic note. And you've argued in several places that India is no longer just a rule taker in this order, but increasingly a rule shaper in the WTO system. Given where the WTO is at this point of time, and also these ad hoc arrangements that seem to be happening, how do you see India in its role as an emerging rule shaper and not a rule taker?
India has always been an active player in the WTO system. So even during the GATT days, India had actually taken up issues which are very important for the global South. So India was considered to be leader of the global South at that time. Then over a period of time, also India has played a very important role. The point is that so there's actually, what I have written and argued is that there is actually a kind of a transnational legal order in the field of international trade or economic law. And these kind of international commitments or international agreements have also impacted the domestic system. To give an example, the competition regime or the anti-dumping regime in the country, or even our own Section 3D of the TRIPS agreement, the patent law. So when you actually, take a WTO commitment and then incorporate that commitment within your domestic system, and then when that particular principle is applied at home, there'll be domestic practices, domestic interpretations. sometimes these are also, in a way exported out of the country.
That's true.
So that is actually that kind of a, interactive relationship is happening. And India has taken up very important issues. Sometimes people accuse India that India has been a spoiler. But the problem is that WTO system is also a system encompassing the entire world. And there are a large number of developing countries within the system. And India has been championing their cause for a very long period of time. And one important thing is that, as you might have heard about the food security. So India really wanted some kind of a carve out or a peace clause with respect to food security in relation to agriculture products. And in the Bali Ministerial Conference in 2013, India was able to actually negotiate with other countries and get a peace clause from dispute settlement with respect to practices like our MSP and other things. So that is a very important thing. So India has been actually, in a way, food security has become a very central pillar of the WTO, especially in the current times with the Ukraine and Russia war and other things. So in a way, India has played a very important role. But the point is that sometimes, there are some criticisms as well that India has been slowing down the process. But I think that is not really I think not really criticism relating to India. Many countries have been blocking it. So the United States uh, is actually, the prime example of that. Yeah.
So let's come to that. Let's come to the appellate body, because one of the key ways in which the WTO system doesn't function now is that it doesn't have a functioning appellate body. So sometimes there are appeals into the void, which means that matters are just left there. Of course, there is an European Union proposal to try and replace that. But at this point of time, nothing seems to be moving. So, insofar as dispute settlement is concerned, and you spoke about food security and how India got a favorable decision, the question that arises is that how should India deal with this gridlocked system of dispute settlement at the WTO? Should India be thinking on its own in terms of a proposal that works for the global south, joining the EU, or should it be a wait or watch to see how this unravels?
I think, in the current times, the wait and watch is a good policy because with respect to WTO, not only the dispute settlement system, as I mentioned earlier, the foundational principles of WTO are actually very much in doubt. So we have to restore the system. The negotiation arm has to function properly. With respect to dispute settlement, again, I think I had to mention one particular point here. The appellate board is dysfunctional, but the WTO is a two-tiered system.
Correct.
And so there is a very active panel system at present. If you really look at even the disputes filed in 2025, China has filed multiple disputes against the United States. Canada has filed cases. So in terms of the activity within the panel stage, it is very active. The only problem is that we can't have a binding dispute settlement. So sometimes, when countries actually get into dispute settlement, they assert their rights and they prove a point. So even if you do not have a binding appellate board decision, even a one-tier panel process is actually good enough in countries, making some kind of a conformity with their international obligations. So my feeling is that India has to remain actively engaged in the dispute settlement reform. What will ultimately happen to the restoration of the appellate body will depend upon domestic positions taken by various countries as well. So at least until 2028, I see very limited prospect of a functional dispute settlement with a two-tier system. The panel stage will continue. The appellate body may not be there until 2028, but things can change very quickly as well.
I mean, things can change overnight because it really depends very much as in on proclivities at this point of time rather than set policy. But coming back to the more critical foundational point that you made about the principles of the global trade order. Now, how does, in your view, as in theoretically, um, India champion its role as a kind of de facto leader of the global south, which it has been at many international forums, um, together with its own use in several cases of some kinds of protective policies, whether it comes to tariffs or industrial policy. There is always this tension that exists in India and in most countries. So, how does India navigate this in at a time when I think the world is calling out for a leader for the global south?
Yeah, the point is that I mean, use of the dispute settlement system is again an assertion of a country's sovereignty. So why India actually became a leader? This one point which I couldn't mention in my previous intervention as well. So India participated very actively in the dispute settlement activity in the early years of WTO. So to give an example, there's a case called the Turkey textiles. So whether the regional trade agreements are actually compatible with the WTO or not. So that was a very important case where India won. And you might have heard about the shrimp turtle case considered to the constitutional case of the WTO. To what extent environmental values can be brought within the trade rules. Then there's a very important case with respect to zeroing and anti-dumping. That was actually a case which India initiated against the European Union. So as a country, India played a very important role in norm making in the WTO legal system. And sometimes you also lose cases. And one important case that I would like to mention is actually India's loss of the quantitative restrictions case and the auto policy. So the point is that any country may actually use the policy space for certain kind of industrial policy making. You need sometimes some import substitution measures. Sometimes you need to provide some policy gap, a space or breathing space to the industry to comply with these kind of rules and regulations. There is nothing wrong in that. The point is that every country is differently situated. The United States and India are not at the same level of development. Industrial policy measure is not completely a bad idea. So even if you look at the last Biden administration, they infused almost 1.5 trillion US dollars in the CHIPS Act and the Inflation Reduction Act, basically for green industrialization. So it is not a bad idea. The point is that countries can always negotiate. So that is actually, I argued in my paper as well. Countries tend to negotiate in the shadow of rules. And that is very important. I think so. Sometimes you may have a difficulty, in complying with a particular position of law, but you can actually use the existing mechanisms in order to get more time, enter into mutually agreed solutions, buy out time. All this. So the negotiation room is very much available within the WTO system. And the last point which I want to mention is that the WTO is not purely an international dispute settlement organization. It is a negotiation forum. Most of the issues will have to be negotiated out in the diplomatic space. But if countries cannot actually resolve it, then dispute settlement becomes the last recourse. So within that space, I think there's enough room for a country like India to take part in norm making and also lead in the South, and not only the South, I think the international community as a whole.
That's right. And I think you make a very important point that countries negotiate in the shadow of rules. And the rules themselves, of course, have always been in a state of flux. They're evolving. And so I wanted to ask you, we can see many new kinds of rules that are now dominating international law, particularly trade. So there are environment linked trade rules, there are national security based trade barriers. There's, of course, a plethora of rules around digital trade. So if I were to look at, I was just reading it the other day. I was reading these EU deforestation regulations, and it seemed like there is a lot there that can be seen as quite protective, but it takes the form of environmental regulation. Because it's harder for some countries to comply with it than others, particularly rules around traceability and so on. So, how would you see India in this space where the rules themselves are changing as an active player? Has India, in your experience, also been responsible in the shaping of these rules? Or how does India negotiate in the shadow of these rules?
Absolutely. I think the point is that in most of the countries, rules are made by, or actually piloted by certain kind of activist groups. So within Europe, the Green Party, the Green Movement actually has been responsible for piloting some of these initiatives. And one important thing I feel is that there is always a contestation and a resistance. So if countries do not actually contest and resist rulemaking, I'm talking about domestic regulation in other countries, like the CBAM in the European Union or the deforestation regulation in the European Union, the voices of the rest of the world will not be taken into account. And again, I mean, this is a very interesting point of international and domestic law as well. To what extent a country can actually regulate, which may have implications for extra which may have implications for exporters and countries outside this jurisdiction.
That's right, because in some sense it's extraterritorial, right? It is.
Absolutely. The point is that when the European Union is actually, cleaning its supply chains by having a deforestation-free regulation, then of course they are also cleaning up the supply chain in India. So the
That's right.
impact and implication will be on other countries, and they will have. The point is that so again, this is actually a very interesting argument. So when you're interested in value-based norm making, shouldn't we have a global, I think a global agenda? So they said that it is actually done under the United Nations Sustainable Development Goals or the Paris Agreement for that matter. But again, that is why these kind of trade negotiations actually help countries in initiating dialogue and making sure that the voices are actually heard. So in Europe, when they come up with a regulation, they actually consult the domestic interested parties, the stakeholders. And their stakeholders should also be international community, like countries like India, Indonesia. And if they do not actually consult other countries, they may be at the risk of losing a case. I'll just complete one point. The EU the EU came up with this renewable energy directive with respect to land use change. Malaysia and Indonesia filed cases, and EU substantially lost the two cases. So the point is that consultation should not be limited domestically, and consultation or other kind of diplomatic processes should be completely used. So that is the lesson we can draw from these things.
So let me flip this question. So how do we build capacity in India so that we can successfully advocate for the position both of as a sovereign nation as well as for industries which are part of this supply chain, our Indian industries which are part of this supply chain, when Europe makes this kind of regulation? I was speaking to some industries which have been impacted by this, and they actually didn't even know of these regulations till after it had happened. So there seems to be a significant lack of capacity both within sort of our trade chambers and trade associations, and maybe even within government. So we need to. So my question to you, as someone who's been heavily involved in directing a lot of work and a lot of Indian thinking on global trade, is how do we build capacity in the nation so that we can successfully intervene or participate in these lawmaking exercises or rule making exercises abroad?
Absolutely, I think this is a very important point. So people actually talk about the development capacity. So when we think about capacity, we should have capacity within the industry, which is considered to be the third pillar of governance actually. So in most cases, the industry cannot really understand this kind of regulation. They are not in the know of things. So, but the point is that who should actually develop this capacity? And what I have realized after going through some of this literature is that in many countries, the state actually takes the role. Exactly. So it is a state-led capacity building initiative. And I think the Indian model is also very good. So currently at the moment, I'm heading the Center for Trade and Investment Law. And we have got around 40-45 lawyers in our center. Earlier, the government did not have an in-house legal team within the government, as you know it, that we do not have a legal service within the Indian bureaucracy. Of course, there are lawyers, but they may not be working on international trade issues or trade law related issues or investment related issues. So the government has taken up that initiative to develop capacity, the legal capacity within the institutions of the government. But that is only a partial way of capacity building. If you really want to have good capacity, then you have to have very good courses in the law universities. We need to have a lot of think tanks. We need to provide space for people to work in this area, and that actually requires money. So the point, many countries have actually experimented it. So in fact, I was involved with Gregory Schaefer in a project called capacity building in law, in international trade law, in the emerging economies. So Brazil actually played a very important role in providing capacity within the third pillar. That is actually the businesses, the small and medium enterprises. The Indian government has actually taken up the initiative in developing capacity within the agencies of the government. That is actually one model. But we should strive towards, an overall capacity building. And that is so important. So when we think about that, law is one pillar, economics is another pillar, policy implication is a third pillar. Then the last pillar is actually, the capacity within the educational institutions. That is so important. So in India now, international trade and investment law is actually taught in most of the law schools. But the point is that if you really want to get good, valuable inputs from these institutions, then the faculty and students should be really doing the what you call as the topical work. And
That's
for
right.
that, I think we need to have money. That is a very important thing, and the people to drive this agenda. Then only we can actually come out ahead.
That's
So
right.
that is the essence of
So
it.
that's actually a really good segue to my last question, which is that a lot of our listeners are law students, young lawyers, and I know that international trade law is seen as quite a sexy subject to study. It's got all these curious cases on shrimps and turtles and all kinds of products which are exciting. There's global in nature. But the practical question is that what does, for a young lawyer or a law student who's graduating, what does a career in international trade law in India look like? And how can they impact in their own way? How can they impact India's trade policy and the larger global order?
Right. So one point I should say, international trade or economic law has actually become very broad based now. So earlier it only spoke about the reduction of tariffs and other things. So now we have got the concept of trade plus issues. So IPR, government procurement, the whole, I think this field has expanded so much. And my feeling is that even if you specialize in areas like intellectual property rights or competition law or subsidy regulation or dumping regulation for that matter, it has got a dimension which is actually in the field of international law.
Mm.
So sometimes I also think about it. Do we need a large number of international lawyers? Sometimes we may not. But at the same time, there should be, I think students should be really grounded in international law. So even if you're actually an IPR lawyer or a dumping lawyer, when you handle an issue, you should realize that there is an international component to it. And that is very important. And that is why some of these big trade disputes actually happen.
That's right.
And I also feel that even in the United States, some of the lawyers may be functioning in a particular niche area, but they can actually use their skill in that area to take up a matter internationally. And that is again a dimension of the globalization. So our skill set should not be purely limited to you can say local requirements. It should be good enough to actually meet the requirements of our clients who may be situated in different jurisdictions. So
That's right. Mm. No, so I think that that's actually something that I say to a lot of students as well. That it's important to have some specializations, but it's also important to be a generalist, to have a solid grounding in international law, so that as in our ability as lawyers is not limited to only a particular area, but we can use that wide foundation. So thank you very much, James. This has been a wonderful conversation. I don't know where the half an hour passed, but I think there's a lot of thoughts there about how the global world order finds itself at an inflection point and how India at this point of time is well poised to ensure that it becomes, in your words, a rule shaper and not a rule taker. Thanks very much for joining us, James.
thank you so much. It is always a pleasure. I just want to add one point that
Sure.
international law is always a fascinating thing, and international trade law has come up with some of the best cases. So even if you do not ultimately end up as an international trade or investment lawyer, going through the process, the methodology, the approach will actually, make you deeply interested in the field of law. And thank you for this invitation. I really enjoyed it.